Welcome to LexTalks, Legal Topics Simplified,
Mm-hmm.
a space to explore law simply and clearly.
Yes.
Today we're diving into the Arbitration and Conciliation Act of 1996 in India,
Right.
focusing on agreements, judicial scope and assistance, interim relief, and the appointment process. It might sound a little dry,
Right.
but trust me, this stuff is surprisingly relevant
Oh, yeah.
to your future as lawyers.
Absolutely.
Okay.
This act is all about giving people options beyond traditional courtrooms.
Okay.
Imagine a world where you could help your clients resolve disputes faster and with more flexibility.
Yeah.
That's the power of arbitration.
I'm intrigued. But let's back up for a second.
Sure.
Could you break down what arbitration IASIS
Yeah.
sees for those who might be
Yeah.
still wrapping their heads around the concept?
Absolutely. Imagine two parties are locked in a disagreement, let's say over a business contract.
Okay.
Instead of battling it out in court, they can agree to have a neutral third party, an arbitrator, make a binding decision. Think of it as a private judge
Right.
whose ruling both sides agree to follow.
So it's like a legal shortcut.
Yeah.
Bypassing all the courtroom drama.
Yeah, in a way, yes. And it's not just about speed.
Okay.
Arbitration often allows for more specialized expertise.
Oh, okay.
For example, a complex construction dispute could be decided by an arbitrator who's an actual engineer,
Right.
someone who truly understands the technical nuances.
Makes a lot of sense, yeah. No more explaining technical jargon to a judge who might not have that industry background. But wouldn't this make things super informal?
Mm-hmm.
Like, are we just shaking hands and hoping for the best?
Not at all. There's a solid legal foundation to all of this.
Okay.
It all starts with the arbitration agreement, a legally binding contract that outlines the scope of the arbitration and gives the arbitrator their power.
Okay.
It has to be in writing, whether it's a separate document or a clause within a larger contract.
So those tidy clauses buried in contracts actually have teeth. They're not just legal mumbo-jumbo.
They are absolutely crucial. A well-drafted agreement is the cornerstone of successful arbitration.
Okay.
Imagine the chaos if a dispute arose and the parties couldn't even agree on whether it fell under the arbitration agreement.
Right.
That's a recipe for disaster.
Okay, that's a headache I definitely want to avoid. So we've got the agreement, a private judge. Sounds pretty straightforward so far.
Okay.
Where do the courts fit into all of this? Do they ever get involved?
They do play a role, but it's limited.
Okay.
Think of them as referees,
Right.
ensuring the game is played fairly. Courts can step in to make sure the arbitration agreement is valid,
Okay.
or to assist with things like gathering evidence.
So they're not micromanaging every decision, but they're there to make sure things don't go completely off the rails.
Exactly.
Got it.
And here's a detail that might surprise you.
Okay.
Even in international arbitrations where the proceedings are happening outside India, Indian courts can still provide assistance under certain sections of the Act.
Wow, that's interesting. So this act has global implications.
Absolutely.
So learning this stuff could help us navigate international cases someday.
Absolutely. In fact,
Wow.
India's 1996 Act is based on the UNC-CITRAL model law,
Okay.
a framework created by the United Nations Commission on International Trade Law.
Uh,
So understanding it gives you a leg up in the world of international arbitration.
okay, I'm starting to see why this is such a big deal.
Right.
But let's be real for a moment. Waiting for any legal decision can be stressful,
Yes.
especially if your client needs immediate protection.
Sure.
What happens if, say, a valuable asset is at risk while everyone is waiting for the arbitrator's final word?
That's a great question. And it brings us to the concept of interim relief.
Okay.
It's a powerful tool that allows arbitrators to issue temporary orders while the main arbitration is underway.
Okay, so it's like a legal safety net protecting people's interests while the bigger issues are being decided.
Precisely.
Okay.
Imagine your client owns a disputed property. The arbitrator could issue an order preventing the other party from selling or damaging it while they're figuring out who rightfully owns it.
Mm-hmm.
It helps maintain a level playing field.
That's a huge relief, literally. It sounds like interim relief is key to preventing irreparable harm
Yes.
while we wait for the arbitrator to, do their thing.
Right.
Speaking of arbitrators, how do we even find the right person for the job?
Right.
Is there, like, a special arbitrator directory we can consult?
It's not quite that simple,
Okay.
but the Act does outline the appointment process,
Okay.
emphasizing independence and impartiality.
Okay.
The agreement itself might specify a particular individual,
Uh-huh.
or it might outline a procedure for selecting one.
Gotcha.
perhaps from a list provided by an arbitration institution.
So there's a system in place to make sure we're getting a neutral expert
Yeah,
who won't favor one side or the other.
exactly. Finding the right arbitrator is crucial. They're not just making decisions.
Yeah.
They're also responsible for managing the entire process, making sure everything runs smoothly and fairly.
It sounds like they have a lot on their plate.
Yeah,
They're not just judges, they're also managers,
right.
mediators, maybe even therapists at times.
You could say that.
They need a unique combination of skills and expertise.
They do.
And here's something else that might surprise you.
Okay.
Did you know that the arbitrator even has the power to appoint a guardian
Yes,
for someone deemed incapable of participating in the proceedings?
they do.
Wow.
It's really
I
important.
didn't realize they had that kind of authority.
Yeah.
It really highlights the level of responsibility they have in ensuring a fair and just process
Right.
for everyone involved.
Absolutely. The arbitrator's role is multifaceted and essential to successful arbitration.
This is all so fascinating. We've covered a lot of ground already,
We have.
from the importance of a well-drafted agreement to the power of interim relief and this crucial role of the arbitrator. It seems like every piece of the puzzle is connected in some way.
It is indeed a complex but fascinating system,
Yeah.
and we're just getting started.
I can't wait to learn more.
Okay.
Let's take a quick break and we'll be right back.
All right.
Welcome back to our deep dive into the Arbitration and Conciliation Act of 1996.
Yeah.
Before the break, we were talking about how courts can sometimes get involved in arbitration,
Right.
even though the goal is to keep things out of traditional courtrooms.
Yes.
What are some other situations where those lines might get a little blurry?
Well, it's a delicate balance for sure.
Right.
One area where courts can play a role is in granting interim relief.
Okay.
Remember we talked about how arbitrators can issue temporary orders to protect assets or prevent harm
Right.
while the arbitration is underway? Well, in certain situations, parties might need to approach the courts for that relief.
I'm trying to picture a scenario where that might happen. Could you give us an example?
Absolutely. Imagine your client is a small business owner embroiled in a dispute with a much larger company. Let's say the larger company is engaging in predatory pricing tactics that are threatening to put your client out of business.
Ooh, that sounds like a classic David versus Goliath situation.
It is. And in a case like that, securing an order to prevent the larger company from those predatory pricing tactics while the arbitration unfolds
Right.
could be a game changer for your client.
I see what you mean. But wouldn't going to court defeat the purpose of choosing arbitration in the first place?
Right.
We're trying to avoid lengthy court battles, right?
That's a valid concern.
Yeah.
And it's why courts are generally hesitant to intervene.
Okay.
The general rule is that once an arbitration has commenced, the court's power to grant interim relief
Right.
becomes more limited. The arbitrator is supposed to be the primary authority for managing the dispute.
Okay, that makes sense. We wouldn't want the courts constantly second-guessing the arbitrator's decisions.
Yeah.
But what if the arbitrator doesn't have the power to grant the specific relief needed?
Oh,
Or what if there's an emergency situation that can't wait for the arbitration process to play out?
those are excellent points.
Yeah.
And thankfully, the Act recognizes those exceptions.
Okay.
For instance, if there's a risk of irreparable harm that the arbitrator can't address,
Right.
the courts might step in.
Okay.
Imagine a situation where the disputed property is literally about to be demolished.
Wow. Okay.
The arbitrator might not have the authority to issue a stop work order, but the courts could.
So it's like having a safety valve in the system.
Yeah.
Ensuring that justice can be served even in time-sensitive situations.
Precisely. It's a delicate balancing act.
Yeah.
Respecting the autonomy of the arbitration process while also ensuring that essential legal protections are available when needed.
As future lawyers, it sounds like we need to be keenly aware of both the limitations
Yes.
and the possibilities of court intervention in arbitration. It's a complex interplay that requires careful consideration.
You're absolutely right. And that complexity is magnified when dealing with international arbitrations.
Right.
Remember, even if the arbitration is seated outside of India, Indian courts can still provide assistance under certain circumstances.
We're talking global lawyering again. I'm picturing a scenario where a dispute spans multiple countries, with assets and parties located all over the world.
Right.
What kind of assistance are we talking about in those situations?
Well, for starters, Indian courts can assist with enforcing interim orders issued by a foreign arbitral tribunal.
Okay.
Imagine a scenario where a foreign tribunal orders a party in India to freeze certain assets.
Right.
Indian courts can help ensure that order is carried out.
So it's about providing practical support for the arbitration process, even when it crosses international borders.
Exactly. It's a testament to the growing importance of international arbitration and the need for legal systems to cooperate in upholding its principles.
No.
The world is becoming increasingly interconnected, and the legal landscape needs to adapt to those realities.
This is all so fascinating, but I can't help but wonder about the practical implications for us as future lawyers.
Yeah.
Let's say we're representing a client who's involved in an international arbitration.
Right.
What are some key things we need to keep in mind to ensure their rights are protected?
That's a great question. First and foremost, you need to be acutely aware of the jurisdictional issues.
Okay.
Which court has the power to intervene and under what circumstances? These are not always straightforward questions,
Right.
especially when dealing with cross-border disputes.
So we're talking about a whole new level of legal research and strategic planning.
Absolutely.
It's not just about knowing the law in our own jurisdiction, but also understanding how it interacts with the laws of other countries.
Exactly. You also need to be mindful of the potential for conflicts of law.
Okay.
Different countries have different legal systems, and it's crucial to understand how those systems interact with the arbitration process.
This is making my head spin a little.
Yeah.
It sounds like international arbitration requires a special kind of legal expertise,
It does.
a blend of domestic and international law.
Yes.
We need to be comfortable navigating not just one legal system, but potentially several.
You hit the nail on the head. It's a challenging but incredibly rewarding area of law.
Yeah.
And with the rise of globalization, this type of expertise is only going to become more valuable in the years to come.
So if any of you listening are looking for a career path that combines legal acumen with global awareness,
Right.
international arbitration might just be your calling.
Mm.
But let's bring it back down to earth for a moment.
Okay.
We've talked a lot about the big picture, but let's delve into another crucial aspect of arbitration that we touched upon earlier, interim relief.
You're right. It's a powerful tool that can have a major impact on the outcome of a dispute.
Yeah.
So it's worth exploring in more depth.
Okay.
Remember, it's all about preserving the status quo and preventing irreparable harm while the main arbitration is underway.
Okay, I'm ready to go deeper. Let's say we're representing a client who's in a dispute over a valuable piece of intellectual property,
Yep.
like a patent or a copyright. They fear that the other party might try to infringe upon their rights
Right.
or exploit the property before the arbitration is complete.
Yeah.
What can we do to protect our client's interests in a situation like that?
That's a perfect example of when interim relief can be a game changer.
Okay.
You can apply to the arbitral tribunal for a temporary order to maintain the status quo. This could involve prohibiting the other party from using, selling, or licensing the intellectual property in question
Okay.
until the dispute is resolved.
So it's like putting a legal shield around the intellectual property,
Right.
preventing further damage while the main proceedings are ongoing.
Exactly. Interim relief is all about leveling the playing field.
Right.
And ensuring that the arbitration process can reach a fair and meaningful conclusion.
Okay.
It prevents parties from taking advantage of the situation while waiting for the final decision.
But I can see how some people might argue that granting interim relief gives one party an unfair advantage.
Sure.
After all, they're essentially getting a head start on the main proceedings,
Yes.
right? What's to stop someone from abusing the system and seeking interim relief, even when it's not truly justified?
Those are important considerations.
Mhm.
And thankfully, the system is designed to prevent such abuses.
Okay.
The party seeking relief has to demonstrate a strong case that their rights are being infringed
Right.
and that without interim measures, they'll suffer irreparable harm.
So it's not just a matter of saying, I'm worried.
Right.
They need to provide concrete evidence and compelling argument to justify their request.
Absolutely. The tribunal has to weigh the potential benefits of granting relief against the potential prejudice to the other party.
Okay.
It's a delicate balancing act that requires careful consideration of all the circumstances.
This is highlighting just how much strategic thinking is involved in arbitration. It's like a game of legal chess, anticipating potential moves and crafting the best possible arguments to protect your client's interests.
You're absolutely right.
Yeah.
And when it comes to interim relief applications, there's an added layer of complexity.
What's that?
The role of the courts.
Right. We talked about how courts have limited power to intervene once an arbitration is started.
Yes.
But how does that play out in the context of interim relief?
Right.
Can parties go running to the court for relief if they don't like what the arbitrator decides?
It's not quite that simple. The general rule is that the arbitral tribunal is the primary authority for granting interim relief.
Okay.
However, as we discussed earlier, there are exceptions.
Right.
For instance, if the tribunal doesn't have the power to grant the specific relief sought, or if there's an urgent need for action that can't wait for the tribunal to convene,
Right.
parties can approach the court.
So it's like a backup system in case the primary mechanism falls short. It ensures that parties have access to those essential legal protections, even if the arbitrator's hands are tied, for whatever reason.
Exactly. The courts act as a safety net,
Okay.
making sure that justice isn't delayed or denied simply because of procedural limitations.
This is all starting to make a lot of sense.
Good.
But I have to admit, I'm still a bit fuzzy on the specific types of interim relief that are available.
Okay.
Can you give us some more concrete examples?
Sure.
We've talked about preventing the sale of property and protecting intellectual property rights.
Right.
But what other options are out there?
Of course. One common type of interim relief is an injunction,
Okay.
which is essentially a court order prohibiting a party from taking a particular action. We touched upon this earlier when talking about stopping the demolition of a disputed property
Right.
or preventing the infringement of intellectual property rights.
So it's a legal tool for freezing the situation, preventing further harm while the main dispute is being sorted out. Kind of like hitting the pause button on certain actions.
Precisely.
Gotcha.
Another type of interim relief is an order for the preservation of assets.
Oh.
This might involve requiring a party to disclose their assets
Oh.
or to take steps to prevent them from being dissipated or hidden.
That makes sense,
Yeah.
especially in cases where there's a concern that one party might try to hide or squander their assets
Right.
before the arbitration is complete. We wouldn't want the winning party to end up with an empty victory,
Exactly.
unable to collect what they're owed.
It's about ensuring that there will be assets available to satisfy any eventual award.
Right.
And then there are more specialized forms of interim relief, such as orders for the appointment of a receiver
Okay.
or for security for costs. These are typically used in more complex cases where there are significant financial interests at stake.
It sounds like the possibilities for interim relief are quite broad,
They are.
tailored to the specific needs of each case.
Right.
It's not a one-size-fits-all solution, which makes sense considering the wide variety of disputes that can be resolved through arbitration.
You're absolutely right. The key takeaway is that interim relief is a flexible and powerful tool that can be used to protect parties' rights during the arbitration process.
Right.
It's an essential part of the arbitration toolkit,
Huh?
and one that every aspiring lawyer should understand.
I couldn't agree more. This deep dive has really opened my eyes to the nuances of interim relief and its crucial role in ensuring a fair and just outcome.
And as you continue your legal studies, I encourage you to delve deeper into the case law surrounding interim relief.
Okay.
It's an evolving area of law, with fascinating legal battles being fought over the scope and limits of these extraordinary powers.
That's a great suggestion. We've covered a lot of ground today,
We have.
from jurisdictional issues in international arbitration to the intricacies of interim relief.
Yes.
It's clear that the world of arbitration is full of complexities and challenges.
It certainly is. But it's also a field filled with opportunities for those who are passionate about finding creative solutions to complex disputes.
Well said. I think we're ready to move on to the final part of our deep dive. Stay tuned as we explore the arbitrator's decision-making process and what happens when a party challenges the final award. Welcome back to the final part of our deep dive into the Arbitration and Conciliation Act of 1996. We've explored a lot,
We have.
from the agreement to interim relief.
Yes.
We even touched upon the global reach of arbitration, but now
Okay.
let's focus on the moment of truth,
Right.
the arbitrator's final decision.
Ah, yes, the arbitral award.
Okay,
This is where the rubber meets the road.
right.
It's the culmination of the entire process.
Uh-huh.
A legally binding document that lays out the resolution to the dispute.
It sounds like a pretty weighty document.
It is.
What exactly needs to be included in an award to make it valid and enforceable?
Well, first and foremost,
Okay,
it has to be clear
okay.
and unambiguous, leaving no room for interpretation.
Imagine the chaos if the award itself was unclear about who owed what
Yeah.
or what actions needed to be taken.
I see what you mean.
It also needs to be enforceable,
Okay.
meaning it has the legal power to compel the parties to comply with its terms.
So it's not just a suggestion or a recommendation.
No.
It's a legal order that can be enforced through the courts if necessary.
Exactly.
That's
And it
smart.
needs to cover all aspects of the resolution,
Uh-huh.
addressing all the issues raised in the dispute.
Okay.
It can include things like who pays the costs of the arbitration,
Right.
any interest payments,
Uh-huh.
and even deadlines for specific actions.
So it's a comprehensive document
Yes,
that ties up all the loose ends and provides a clear roadmap for moving forward.
precisely.
Gotcha. And here's another interesting point you made.
Okay.
Even if the parties reach a settlement during the arbitration process,
Mm-hmm.
it's still recorded as an award.
It is.
Wait, really? Why is that? I thought the point of settling was to avoid a formal decision.
That's a great question.
Yeah.
Recording a settlement as an award ensures it has the same legal weight
Okay.
and enforceability as any other arbitral award.
Right.
This protects the parties from one side later trying to back out of the agreement, claiming it wasn't binding.
That's a clever safeguard.
Yeah,
It adds an extra layer of security to the settlement process.
it does.
But what happens if one party is truly unhappy with the final award,
Okay.
even if it's technically valid? Do they have any recourse?
That's where the grounds for challenging an award come into play.
Okay.
The Act outlines very specific situations where a party can seek to have an award set aside by the courts.
Okay.
But it's not a simple matter of disagreeing with the outcome.
Right.
There needs to be a legitimate legal basis for the challenge.
So it's not a get-out-of-jail-free card,
Right.
just because someone doesn't like the result. What are some of those grounds for challenging an award?
One ground is if the arbitrator exceeded their authority.
Okay.
This could happen if they decided on matters that were outside the scope of the arbitration agreement.
Right. Or if they applied the wrong law. Another ground is if there was a serious procedural irregularity that affected the fairness of the proceedings.
Could you give us an example of what that might look like in practice?
Certainly.
Yeah.
Imagine a situation where one party was denied the opportunity to present key evidence,
Right.
or where the arbitrator displayed clear bias toward one side.
Okay.
Those could be grounds for challenging the award.
Gotcha.
However, it's important to remember
Okay.
that courts are generally reluctant to interfere with arbitral awards.
Why is that? Shouldn't they step in if there's evidence of unfairness?
They absolutely would if there was a clear violation of the law or due process.
Right.
But courts also recognize that arbitration is a private process,
Okay.
that parties have chosen to resolve their disputes.
Right.
They don't want to undermine that autonomy unless there are compelling reasons to do so.
So the bar for setting aside an award is quite high. It's not just a matter of second-guessing the arbitrator's judgment.
Exactly. There has to be a serious error or misconduct that goes to the heart of the arbitration process.
Right.
Remember, a domestic award is treated like a court decree, so it carries significant legal weight.
This makes me think about the practical implications for us as lawyers.
Yes,
How do we advise our clients on the prospects of successfully challenging an award?
that's a good question.
It sounds like a delicate balancing act.
It is.
Yeah.
We need to carefully analyze the facts of the case,
Uh-huh.
the relevant legal principles,
Right.
and the strength of the grounds for challenge.
Okay.
We need to be realistic with our clients about their chances of success.
Right.
Sometimes it might be better to accept the award,
Okay.
even if it's not ideal,
Right.
rather than risk a costly and potentially unsuccessful legal battle.
It's about weighing the costs and benefits of further litigation
Exactly.
and making a strategic decision.
Yeah.
That aligns with our client's best interests.
Precisely.
Okay. And it's important to remember that even if a challenge is successful
Right.
and the award is set aside,
Yeah.
it doesn't necessarily mean the dispute is over.
No, it doesn't.
It might mean going back to the drawing board,
Right.
perhaps even starting a new arbitration.
Exactly.
Wow, this is really highlighting the complexity of the arbitration process.
It is complex.
There's so many layers to consider.
There are.
But let's shift gears for a moment
Okay.
and talk about the flip side,
Right.
enforcing an award.
Right.
What happens if the losing party simply refuses to comply with the arbitrator's decision?
That's where the enforcement mechanisms come in.
Okay.
Thankfully, the Act provides a clear path for turning that award into action.
Okay. How does that work?
Well,
Is it like enforcing a regular court judgment?
exactly.
Okay.
A domestic arbitral award can be enforced just like a court decree.
Uh-huh.
The winning party can ask the court to take steps to compel the losing party to comply with the terms of the award.
Right.
This could involve things like seizing assets,
Okay.
garnishing wages,
Right.
or even imposing fines for noncompliance.
So there are real consequences for ignoring an arbitral award.
There are.
It's not just a piece of paper that can be tossed aside.
Absolutely not.
What's even more fascinating
Yes.
is that the Act also provides a mechanism for enforcing foreign awards in India
Right.
under certain conditions.
Yes.
This speaks to the increasing globalization of dispute resolution
It does.
and the need for cross-border cooperation in upholding the principles of arbitration.
It does.
It's like a global legal network working together to ensure that justice is served,
It is.
even when disputes cross international borders.
Indeed. Of course, enforcing a foreign award isn't always a straightforward process.
Right.
There are specific conditions that need to be met, and it often involves navigating the complexities of different legal systems.
It sounds like another area where specialized legal expertise is essential.
Absolutely.
We've covered so much ground in this deep dive into the Arbitration and Conciliation Act of 1996,
We have.
from the initial agreement to the final award,
Right.
and everything in between. It's clear that this act provides a robust and flexible framework
It does.
for resolving disputes outside of traditional courtrooms.
It does.
It's been a pleasure exploring this fascinating area of law with you.
Likewise.
I hope our listeners have gained a deeper understanding of the power and potential of arbitration.
I hope so too.
It's been an incredible journey.
It has.
And to all our listeners, thank you for joining us on LexTalks.
Yes.
We hope you found this deep dive valuable.
We do.
Don't forget to subscribe and keep learning with us.
Absolutely.
Until next time.
See you then.